Hello, everyone, and good afternoon. We have this workshop in the Las Casas Institute today online in order to gather these 6 participants for a European challenge, the defense of human rights in the digital age. As you probably all of you know, the Las Casas Institute is inspired by the 16th century friar Bartolomé de las Casas, who was probably born in Seville in 1474. It is a little bit doubtful, but still, he championed the rights of indigenous peoples in the Americas, partly by enlisting the academic support of his fellow friars at the University of Salamanca. Named after this renowned figure, the Las Casas Institute conducts and promotes research into Christian humanism and its application to contemporary social issues. The Institute brings together a growing community of scholars, primarily lay women and men, who draw on the rich tradition on Catholic social thought, teaching and practice. Among the challenging questions we consider are: how should we safeguard the dignity of migrants while protecting the rights of existing citizens and safeguarding culture and national security? Or what enduring value does the traditional concept of human dignity have in an age when technology offers easier way to end lives and change bodies? For example, this workshop of today can deal with this particular question. No? The Institute's research is disseminated to wider society through conferences, talks, books, online resources, and so on. One of the Institute's main research interests is human rights, and since becoming an associate member and subsequently a research fellow, I have endeavored to promote research events and publication in this field, which is pivotal to the preservation of human civilization. Human rights are in crisis around the world, we all know that, and many believe that humanity is progressing in this area, despite it being one of the greatest achievements of the last few centuries. For this reason, I'm organizing a series of workshops for relevant European experts and arranging for their work to be published in an appropriate academic journal. The aim is to shed light on aspects of human rights protection in Europe and the challenges ahead if Europe is to continue to be considered the continent of human rights. Over the next year, we will hold 2 public workshops to discuss 6 topics under the broad umbrella of the European Challenge, Defending Human Rights in the Digital Age, and our conclusion will then be published in a special edition of a prestigious European Studies journal. The first workshop is taking place today. We will present the topics and the initial stage of our research. The second workshop will take place in November, when we will present our conclusions before submitting our papers to the journal for publications. My own university, CEU Fernando III, is also creating a research center in international relations named after Thomas More, a great figure of Christian humanism and Oxford University. I will have the honor of directing this center, which will conduct and promote research into the main problems affecting international society in our time. I hope that this event, organized jointly by the Las Casas Institute at the Thomas More Research Center at CEU Fernando III, will be the first of many collaborations. I will now hand over to Richard Finn, director of the Las Casas Institute, who will moderate this workshop and introduce each participant. I would like to thank them all for accepting my invitation to take part in this activity.
Carlos, thank you very much for your introduction. Thank you also for organizing this series of webinars on this really important topic and set of themes. Without further ado, welcoming everyone to this meeting, I would like to introduce our first speaker this evening. The speaker is Professor Carlos Fernández Liesa, who is full professor of public international law at Carlos III University in Madrid. He was recently appointed to the UN Human Rights Committee for the period 2025 to 2028. He's held many other distinguished positions, including Secretary General and Vice Rector of his own university, and again, Director of the Francisco de Vitoria Institute. He's currently Vice President of the Peches Barber Foundation for Human Rights. Carlos's main areas of research include international organizations, human rights, the history of international law, sustainable development, international cooperation, the international protection of culture, and global risks. His many achievements allow us to consider him as one of the most important figures in the field of human rights studies and advocacy. Professor Liesa, thank you so much for agreeing to take part in this debate. Over to you.
Thank you very much, Professor Richard Finn, Director of the Bartolomé de las Casas Institute, and thank you very much to the research coordinator, Professor Carlos Espaliú, and to the other colleagues for being here and for doing these research projects on human rights all together. No? It is an honor for me to work with all of you. My topic in this collective research project is sustainability and human rights in the European Union. Sustainability is a broad concept, but I propose it to Carlos because I think it is interesting from an academic point of view. I have been working for several years on the 2030 agenda and sustainability to analyze how this is relevant to human rights. The notion of sustainability is broad. However, it is a term used in law as a bridge or connecting point between three things: ecology, sustainable economy, and sustainable society. In the European Union, sustainability appears in the preamble, which refers to the principle of sustainable development within the context of the competition of the internal market, the strengthening of cohesion, and the protection of the environment. Article 3.3 on the internal market also refers to sustainable development as balanced growth, social economy, and the environment. And in the field of foreign policy, there are references to sustainable development in Articles 3.21, the latter also referring to sustainable economic, social, and environmental development. The European Union is adapted to a principle that has been further developed mainly since the 2030 agenda. In this respect, the Treaty of European Union is innovative and modern. However, when we turn to the Charter of Fundamental Rights, the principle of sustainable development only appears in Article 37, linked to the environment in a classical vision. My work aims to see to what extent the European Union principle of sustainability has penetrated human rights and the economy, and not just the environment, through the ecological transition. In my proposal, I also refer to the European Union role in the world. Europe's contribution to a sustainable world is necessary, but the European Union is not in a good place at the moment. There are many double standards. In a changing world, the European Union should have a different discourse. To preserve the legacy of human rights in today's world, Europe should do things differently, which is not doing. This applies not only to current problems but also to the longer-term discourse and reality. This is even less the case on certain issues such as migration, where the European message has for decades been contrary to human rights values. Before I go, I would like to reiterate that it is an honor for me to work with an international team at Oxford, led by Professor Carlos Espaliú. I am also honored to be able to do so within the framework of the activities of the Bartolomé de las Casas Institute, an inspiring figure of values for almost 5 centuries. His message was pioneered in modern times, together with Victoria, in the origins of international human rights law. I think it is wonderful that the University of Oxford has a center in his memory, and that I am able to collaborate with it. Thank you very much.
Thank you very much, Professor. Thank you for setting out both that set of what's enshrined in law, but also alerting us to the significant gap between law and practice. Obviously, there will be time for discussion later on this afternoon, but we're going to move on straight away to our next speaker. This is Professor Claes Granmar, who is researcher and associate professor specializing in European law and the European Court of Human Rights. He's an alumnus of Oxford, where he was a visiting fellow at the Institute for European and Comparative Law in 2017 to 2018, and a member of the Senior Common Room at Lady Margaret Hall. He wrote his dissertation on trademark rights and brand competition at the European University Institute in Florence, and also worked at Stockholm. He's worked at the EFTA court in Luxembourg, and his field of research has gradually extended to encompass more aspects of EU internal market law and external trade relations in the context of constitutional pluralism. And Claes founded the Nordic Forum for EHCR Studies and is currently focusing on digital globalization and fundamental rights. I don't know if you're also going to comment on the trade deal between the EU and the UK that was finalized yesterday. But Claes, over to you, and thank you.
Well, thank you very much for these welcoming words and this brilliant presentation. I really appreciate this, and I also appreciate to be part of this project, and I'm honored to be invited by Professor Carlos Espaliú, and I will do my best to bring well, some aspects into this context and this project. My topic is protection of fundamental rights through external trade relations. Then I realized that the whole project is about the European challenge defending human rights in the digital age. So I had to add another element to this topic, namely digitalization. And I prepared something which is rather structural EU law approach to all this. It's some kind of starting point for my contribution. I hope to write up a chapter on this. So I will try to share some slides with you. I hope you can see my slides on the screen. Thank you.
Yes.
So it's just well, I've been working a lot with AI recently, and as also with the implementation of AI in the pharmaceutical or in the medical sector. So I brought this into the picture, and the main question then when it comes to digitalization, there are two things. The first thing is law as a concept. The other thing is geography as a definition of jurisdiction. So when it comes to the first aspect here, what can law do about anything really? I think it's still about legal entities. We have to regulate humans and companies, not machines. So we had to regulate source codes basically, because the source codes are normatives for the machines. And then when it comes to law, it's also interesting because it can be used to implement political decisions, of course. And we have this tendency of even using law to make away with democracy because you have the power to do so. There are some constitutional restraints, but you can change the constitution as well. But from an EU law perspective, I think the starting point is really the reverse, that law is a way to limit the leeway for those in power to decide, because law is based on an international agreement. It's anchored in fundamental rights nowadays since 2009. So it's pacta sunt servanda, and you can't really vote that away. You have to change the treaties, and that takes 27 member states consenting to that. So it's kind of stabilizing the fundamental rights basis for a polity in that sense. And you can see it in this, things are changing rapidly, and you can see that the democracy, I mean, the biggest democracy in the world, suddenly turns into something, a bad version of democracy, to speak. And then you can see this kind of normative or legislative approach to how to build a society as a bulwark against technopopulism, perhaps. So EU is really based on fundamental rights and law, and that is the kind of foundation for the whole project. And this must also, and ultimately, the rule of law is not, I have come to this insight, so to speak, that the rule of law on EU level is not so much anchored in political processes as in pacta sunt servanda. So, and consistency is kind of the main justification ground for what is good law in the European Union. And we have this written into the treaties. It's just based, for my own memory, basically I've been talking about this the whole day with the students, so I'm a bit exhausted hearing myself talking, but I will try to get some energy. And of course, Article 19 is the starting point. Ultimately, the European Court of Justice has to decide what is good law based on the treaties. And they have to ensure that the law is observed, which is absurd in a way, because what is the law if not the treaties? How can you assess and interpret the treaties on basis of the law if the treaties are the highest source of law? Well, it's because in the treaties we have some meta norms. I call it a source code of the unification process that the court and also the Commission will always try to abide by. Is the to ensure the realization of the objectives. It's written into Article 5.2. And it's the consistency, as mentioned, as is the really center of the whole unification process. This applies also, I think, in the external relations. So when it comes to objectives and the objectives of the European Union, we find them in Article 3. It's to ensure the values. The values are defined in Article 2. And among the values, you find democracy and and human rights. And nowadays, in Article 6.1, we find the basis for the EU Charter, saying that the Charter has the same legal value as the treaties. So whatever the Union is doing, you need to take the fundamental rights into consideration. This is something you can't vote away, and there would be also a basis for revoking any action by the European Union not to abide by the fundamental rights in the Charter. So, of course, they can take this into consideration to more or less degree, but it's not good law if you don't ensure that the actions are in accordance with the fundamental rights. And the Convention for Fundamental Rights is also then recognized as basic principles of the European Union still today. So just to go through these basics, that in Article 3.5, the Union and then the Commission must take fundamental rights, human rights into consideration, also when they enter into trade agreements and in all the external actions. So this is something that the Commission cannot really disregard. When they negotiate with China, they try now to be more creative, but they cannot disregard some basic fundamental rights, because that would be an invalid agreement under EU law. And it's not a government that can have support from their people doing this. No, it's not. There will always be a basis for revoking this action. So it's really based on law. And in Article 21, it's reiterated then that you must take this interest into consideration in external relations. And now I move on to what I'm going to focus on in my article later on, namely this collapse between the external and internal dimension. Because on the one hand, you have the Commission doing things and they're talking with the governments around the world, trying to enter into agreement and setting up a trade agreement, investment protection agreement, and all that based on the fundamental rights at some level. But the tricky thing when it comes to, for instance, the USA, is that most of the trade barriers are created behind the borders. That is the internal market regulation that actually set the standards for external relations of the European Union in the digital era. And the main legal framework here for the time being is the Digital Service Act. And you don't see the whole, but you can read it by yourself. But it's basically saying that as soon as you have a company established in the European Union, or those who use the services are in the European Union, then the DSA applies. So it doesn't matter if you have a company established in the USA or in China or in Australia. If you are going to have a platform that provides services in the European Union, you need to abide by the fundamental rights of the European Union. And this has been very, very tangible now for US and Chinese companies. TikTok and X and all these are suffering. They are subject to heavy fines now from the European Commission because they don't abide by fundamental rights. The problem with the platforms are always that they can claim to be just mediators, passive mediators. The content is provided by someone else. We do not have anything to do with it. So we still have this basic activity requirement that you must show that the platform has been involved in the content, producing of the content at some level, or at least they have not recognized complaints about the content and taken down the content more or less immediately. This goes to technology now because, of course, with AI systems and all that, the requirements are increasing that you must, as a big platform, be able to filter the content and take away the content instantly. So if you don't do that, you will be having an obligation as a policeman for the European Union. If you want to have a big platform in the European Union, you're becoming a part of the enforcement of EU law, whether you like it or not. And of course, we had intervention, and we had this intervention in the Romanian election recently. And of course, it was not TikTok that provided this information and promoted this candidate from the ultra-right side of the spectrum. It was Russian fabrics, content fabrics doing this. But the algorithms were a little bit open to this and more welcoming to this kind of opinions than more critical opinion to this. So that in itself was a problem, but also that they did not react. They did not, as a big platform, we also have this obligation on Article 34 and 35 to all the time monitor and assess the content on your websites and to take measures, technologically speaking, I would say, to prevent all kinds of illegal content infringing fundamental rights. Of course, human dignity is of essence. Human dignity is a starting point. That is why machines cannot have fundamental rights, because dignity is a human thing. You can perhaps extend it to some other creatures, but human rights belong to humans, not even our best friend. The dog can have rights like that, so why should machines have it, so to speak? So if you infringe those rights and you don't take measures as a big platform to prevent that from happening, you can be held liable. This has happened now in both the case with X and Facebook, and now most recently with TikTok. There is one other thing with these measures to prevent infringement of fundamental rights is the so-called rabbit holes, because in itself the algorithms are designed to lock in people in these echo chambers and rooms. They are showing an interest in certain topics and certain activities, and then they get more and more of these, and they get less in everything else. So you're kind of narrowing down the worldview of the people, and especially young people are suffering now. And you have studies showing that there are also a case of mental illness and even suicides and so on, depending because of this. So there's a liability for the platforms imposed on them. So they are no longer objective mediators. They are, in the European view, responsible for upholding fundamental rights. They are part of the policing of fundamental rights in the European Union. And this is a surprise, I guess, for the American and Chinese companies, that they suddenly have become, so to speak, helpers of the EU legislator, because EU law is based on the rule of law, which encompasses fundamental rights. This is nothing you can vote away or have PR campaigns swaying people to, bread and spectacles to change opinions of people. It doesn't really matter, because as long as not 27 countries agree to change the treaties, this is the basics, the legal framework that decides the social development, determines the social development in the European Union. So my last point would be that law has to respond to changing realities, but law also creates realities. And when it comes to the AI producers, this has become, I think, an awakening call now, when the AI Act was also introduced, requiring them to have transparent algorithms to say we can't do it. But then the reality might be that you cannot sell your system in the European Union. And that is a shocking news for some entrepreneurs that think that whatever we can do, that we should do. And we create the reality by creating new technology. That is not the European approach. This legally based approach is really to create reality by law. And the main objective is to keep it human-centric, the whole social development, and to prevent some technology from being deployed. In the long run, I think this is a sustainable approach. In the short term, we may lose out to some companies. That's another story. But so I'm going to focus on this, which I find very, very interesting, actually, to look at the internal regulation and its effect on its external relations. And because in the international trade agreements I'm looking at, it's not very much about e-commerce at all, or data protection. It's basically referring to the parties' internal regimes. So there's no longer, this has been a collapse between the external and internal dimension to the benefits of human rights, I would say. Well, thank you for, I took a little bit longer than expected, but I hope I convey some message at least.
Claes, thank you very much for that. And of course, raising issues that are very much at the sharp end of these things with respect to the Romania election and with respect to TikTok and the so-called rabbit holes. Thank you so much for that. And now I'd like to invite Professor Sonia Boulos to talk to us. She's Professor of International Human Rights Law at the Faculty of Law and International Relations at Nebrija University. She holds a doctorate in legal sciences from the University of Notre Dame in the States. She was awarded a Fulbright scholarship to undertake her doctoral studies. Her research focuses on the international protection of human rights. And she's co-editor of the Pennsylvania State University published Palestine-Israel Review. She has participated in several international and national research projects and acted as principal investigator of the Nebrija team in 2 European projects funded by the Horizon 2020 program. She is the principal investigator of the Segerico Research Group on Security, Risk Management and Conflict at Nebrija University. Professor Boulos, thank you very much for agreeing to talk to us this afternoon. Over to you.
Thank you for inviting me, and then specifically to Carlos. I don't know how many of you know that, I was the assistant, principal investigator when Carlos was the principal investigator of Segerico. So for me, it has also, I'm very grateful for this invitation for different kind of reasons. I need to share my slides, so please, if you can, I cannot do that. If the others speak, okay. Can you see my slides now?
Yes.
Okay. So my presentation is going to be very basic. And it's very basic, not because, you know, the research is, it's very basic because unfortunately, when I'm going, the issue that I'm going to talk about, you know, the EU, you know, is stuck in this discussion that is really basic with basic questions instead of asking the more complicated question in relation to the advisory opinion. I don't know if it's ironic or not, but today actually there is a debate at the EU, you know, to see whether the EU should suspend its agreement with Israel. So I'm going to focus a little bit on the implications of the advisory opinion of the International Court of Justice for the EU, and an advisory opinion in relation to the illegal presence, continued presence of Israel in the occupied Palestinian territories.
Start a 30-day free trial from Adobe Stock.
Okay. So I'm sure most of you know more or less what the advisory opinion is about. So basically what the International Court of Justice said, that Israel's continued presence in the OPT is a wrongful act of a continuous character that entails international responsibility. So why the court decided that the Israeli presence is illegal? Because it violates two key norms of international law, which is the prohibition on the acquisition of territory by force, and it violates the right to self-determination of the Palestinian people. In the operative part of the advisory opinion, the ICJ also identified certain violations as erga omnes violations, which, you know, by definition have implications for the international community. So what are the violations that the court classified as erga omnes? Well, the obligation the obligation not to acquire territories by force, you know, violating the right to self-determination of Palestinians, and also other obligations under international humanitarian law and international human rights law. Now, this had implications, and the advisory opinion itself is very clear about the implication that this has for, you know, third states, and this includes also international organizations. For basically the summary, first of all, states and also international organizations cannot recognize as legal situation that is, you know, unlawful, such as the Israeli presence in the occupied Palestinian territories. And then there's a duty not to render aid or assistance in maintaining the situation, to ensure that any impediment resulting from the illegal presence of Israel in the occupied territories to the exercise of the Palestinian people's right to self-determination is brought to an end. And also there are some obligations in relation to the Fourth Geneva Convention that member states have to do something to make sure that Israel is respecting that. Now, one of the main points that are very relevant to the EU is the fact that the court says we must distinguish in our dealings with Israel between the territory of the State of Israel and the OPT. And this has all sorts of, you know, implications. So I just chose the most basic ones. First of all, the obligation to abstain from treaty relations with Israel in all cases in which Israel, you know, behaves as the sovereign in the West Bank. That is a big no. To abstain from entering into economic or trade dealing with Israel concerning the occupied Palestinian territories that entrench, you know, the unlawful presence of Israel. To abstain from establishing or maintaining diplomatic missions in the occupied Palestinian territories. And most importantly, to take steps to prevent trade or investment relations that assist in the maintenance of the illegal situation. Now, the question of what kind of obligations that this would entail for the EU, it could be addressed from two perspectives. When I start, you know, it could be addressed from an internal perspective, focusing on the EU law itself and what it would, you know, how it would guide us in relation to these kinds of obligations. Or it could be addressed from a kind of international law point of view, not necessarily internal to the EU laws. And this is what I tried to do at the beginning of the, you know, when I started working on this. But at the same time, it's important to have some perspective from the inside. So if we look at the EU law, we have at least three provisions kind of, you know, try to orient us into this. We have Article 3.5 of the Treaty of the European Union, which clearly states that in its relations with the wider world, the Union shall uphold and promote its values. Then we have Article 21 that talks about the EU being guided by its own principles in its action on the international scene. And then we have Article 21.3.1, which says that the EU must respect its own values in relation to democracy, human rights, etc., in the development and implementation of different areas of external action of the EU. Now, in one of the cases, the European Court, Justice made it clear that under Article 3.5, when the EU, is acting, it must contribute, with strict observance, and that's a quote from the case, and the development of international law. When it adopts an act, it's bound to observe international law in its entirety. However, there is a question if we are looking at this from an internal point of view. So, for example, Bartels argues that it's very clear, it's very easy to say that when the EU is acting, it must make sure that its own actions are not violating human rights. But that is not to say that the EU has some sort of an obligation to protect human rights when the violation stems from another actor, which is not the EU, or whether the EU has any right to fulfill the human rights of other peoples when the violation is not attributed to the EU. So while the first part is very clear that the EU in its action must be careful, the second part seems to be that as an internal question, the answer is not very clear. Now, talking about the EU-Israel Association Agreement, well, it has all the agreements that the EU, had signed before with other states. It regulates trade and investment, and also framework for participation in, educational programs such as Horizon, etc. So there is a human rights clause in the agreement, which is very common. It's, to all agreements. And it says relations between the parties, as well as the provisions of the agreement itself, shall be based on respect for human rights and democratic principles, which guides their internal and international policy and constitute an essential element of this agreement. Also, there is a provision on the suspension of the agreement, which allows the EU to suspend an agreement when one of the parties is not meeting its obligations. Now, there is a process to do that. First of all, if one of the parties one country is arguing that this should be suspended, they should, first of all, supply the Association Council with relevant information, and then they try to seek a solution that is agreed upon all parties, including Israel. So there is some kind of, prioritization of dialogue with the violating states, and also, opting for the solution that disturbs less the agreement. Now, I don't want to take too much time, but, there's a substantial trade, relationship between Israel and the EU. I just, downloaded this data from the EU official website. So Israel is the third biggest trading partner in the Mediterranean region after Morocco and Algeria. The EU is Israel's biggest trading partner, accounting for 32% of total trade, etc. So this, I'm not gonna spend more time on that now. So the question is this all an empty rhetoric in the sense that, we have to make sure that we don't have, agreements with countries that, consistently violate basic international human rights norms? So just to, for example, when the advisory opinion was issued, the director of the EU Foreign Service Legal Department argued that we label products that come from settlements, and if you want us to do more, so this is a political question. I mean, it's not for me, it's not a legal question. Of course, there was a backlash in the international human rights law community, and UN also rapporteurs who clearly argued that this position is legally flawed, politically damaging, and morally problematic. So although now the Netherlands is credited for the discussions that were going to happen today in relation to the agreement, but actually it was Ireland and Spain in a joint letter in February 2024 who asked to review the agreement. There's an interesting case that could be relevant to understanding this. It's the Morabi case, in which the European Court of Justice says the fact that states can suspend an agreement based on human rights clause doesn't mean that states have to do that, that they are under the obligation. But this is the point of view if we think about violations of what we call jus cogens norms. Beyond the advisory opinion, there's also now, we could argue that under a customary law, there is a duty to prevent also a genocide. That's a legal duty that states and also international organizations should follow. This is, from the case on Bosnia-Serbia case, the courts hints that there's an active duty of preventing genocide. And there's the argument that this is today part of customary law. Now, although the court classified only the violation of self-determination as a jus cogens norm, the other violations that were identified by the court can also be considered jus cogens violations. For example, the International Law Commission classified the prohibition on aggression, basic rules of humanitarian law, the prohibition on racial discrimination and apartheid, and the right to self-determination. All of these norms are considered jus cogens norms. So even Judge Tladi, in his separate opinion, kind of criticized the court by saying that the fact that their states have duties is not because we're talking about erga omnes obligations. It is because we are talking about jus cogens obligations. And that is the key point. So if we take this analysis, it is clear that if we're talking about jus cogens violations, going to the Article 421 of the draft articles of the responsibility of states for international wrongful acts. So clearly this gives rise to an obligation, first of all, not to recognize and then not to assist in any way. Clearly, for example, Ronen clearly says that the language that was used by the court, such as, the terminology sustained, prolonged occupation, continued, tries to put the situation under the umbrella of Article 41 that I just quoted. So where do I want to lead with this? That even if the court says, European Court, that there is no obligation to suspend an agreement in the case of human rights violations. If the human rights violations we're talking about are jus cogens violations, there is a clear duty. It doesn't stem necessarily from internal EU law. It is basic international law principles. Now, I just want to finish to show some of the measures that were suggested by UN rapporteurs and special procedures mandate holders. The basic one would be immediately review all the diplomatic, political, economic interaction with Israel, impose a full arms embargo on Israel, especially in relation to the war in Gaza, make sure that anyone who's benefiting from the occupation of the West Bank is not going to be a trade partner. To also cancel and suspend economic relations with those who are trading in a way that violates international law, and including imposing certain sanctions and recent legislations that also criminalize to some extent, calling for the imposition of sanctions. If you see this map, you can see that the European Union have suspended more than 15 agreements before based on human rights violations. So it seems that Israel is going to be, so far has been a very kind of disturbing exception in the sense if we compare, what kind of human rights violations we are talking about. So unfortunately, this is a very basic presentation, as I said before. I'm not digging into the hard stuff. And the hard stuff is not the question whether we should do something about it, it's the question, how do we do it? For example, how do you segregate, how you separate the Israeli economy from the economy of the, the colonies in the West Bank? This is the tough question. This is the more challenging one, because the court didn't, call for blanket disruption of commercial relations with Israel, but the distinction. But unfortunately, in the EU, we're not even there. We're just basically debating basic questions. So that's what my paper is going to focus on. And I apologize if I took more time than I should. Thank you.
Richard, microphone.
My apologies. Thank you, Professor. We're going to pass now to Professor Susana Sanz Caballero, who's Professor of Public International Law at the University CEU Cardenal Herrera and has been there since 2008. She's currently at CUNY on a postdoctoral Fulbright Schumann Scholarship granted by the Department of State and the European Commission. And she holds the Jean Monnet Chair of the European Commission and is a member of the Council of the Fondation René Cassin International Institute of Human Rights. She's an expert with a diploma of expertise at the International Institute of Human Rights in Strasbourg, Master of Arts in Social Sciences of the One March Foundation, and she is an ad hoc judge of the European Court of Human Rights. For 2 years, Professor Sanz Caballero was the senior advisor of the EU in its structured dialogues with Brazil in the field of human rights, and she currently leads a national research project on the rule of law backsliding in the EU, with 15 researchers from 6 European states. Professor, over to you, and thank you so much for speaking this afternoon.
Thank you very much. First of all, I would like to express, of course, my gratitude to Professor Espaliú and Professor Finn for inviting me to take part in this event with such a remarkable group of scholars. From what I heard, I'm really overwhelmed. I believe this is not a one-time event, and this is exactly the kind of opportunity one cannot decline, because it's about building networks, identifying synergies that I'm finding now, and encouraging the cross-pollination of ideas. So yeah, as you said, I'm currently on a post-doctoral Fulbright scholarship in New York, and more specifically, I'm working on a comparative research between the European Union and the United States in the field of the rule of law. So being based in the USA, I am observing from a very privileged standpoint this interesting moment marked not only by the recent change in the US administration, but also by significant electoral developments in several European member states, as we saw last weekend in Poland, Portugal, Romania, and before that in Germany. So, well, at the same time, I think we are living in a period of high uncertainty, instability, and very rapid change, which poses both analytical and practical challenges. I must admit that when Professor Espaliú initially invited me to participate in this activity, I was somehow hesitant. The original focus of the initiative, which is the challenges for the European Union in the field of human rights in the digital era, was not part of my current Fulbright research. However, Professor Espaliú kindly proposed that I could shift the focus from the digital to the erosion of the rule of law. And with this adjustment, well, I feel much more comfortable now, better positioned to contribute to the discussion, even if very humbly. So I would like to know that, as I understand, today's event is intended as a space to present work in process. And that is exactly my case, because what I will present is truly a work in progress. Because I have started my research, but I'm fully aware that there is so much work ahead still. So this brings me to the topic I've chosen for presentation, which is the fragility of human rights in times of rule of law erosion, to which I have recently added a subtitle, namely Case Studies from America and Europe. So what I will do now is to outline the main points of my planned research, explaining what I have done so far and what I will have to do as I move forward in the next months. So let's go for the first part of my contribution. My objective is to explore the connection between the rule of law and the protection of human rights. As a preliminary point of or as a hypothesis, I don't know what it is, but there are two sides to the same coin. I firmly believe that if a country does not uphold the rule of law, human rights will not be protected effectively, and that was said before also by another colleague. And likewise, if human rights are not respected, a genuine rule of law will not exist. Although the ideas I develop in my contribution can apply to any democratic regime anywhere in the world, my analysis in this first section revolves primarily around the Treaty of the European Union, that was mentioned also before, and it's Article 2, the European Charter of Fundamental Rights, which was also mentioned, and the work of the Council of Europe, particularly as set in Article 3 of the founding treaty, the London Convention of 1949, and in the European Convention of Human Rights. So the first objective is to demonstrate the existence of a very strong and mutually reinforcing relationship between the rule of law and human rights. And to achieve this, I will define what the rule of law entails. As said, when the rule of law is undermined, sooner rather than later, human rights will be undermined as well. Rule of law decay has a cascade effect on human rights, as both individual and collective rights are fully respected only in democratic, rule-abiding states. The very essence of the rule of law relates to the respect of human rights. Indeed, one may question whether human rights can survive the ongoing global constant assault on the rule of law, and this is I really wonder, this is a really big concern. These two values are not just part of the European Union legal framework, they define the political and constitutional meaning of what being part of the Union means, and they are embedded in Article 2 of the Treaty of the European Union. One cannot exist without the other. But when we speak of the rule of law, we are not just referring to the existence of laws and procedures, that was also mentioned before. We're referring to a system where legality, legal certainty, access to justice, equality before the law, and freedom of expression are guaranteed. That is, a system where human rights are protected. This means that the rule of law is not just about laws being applied, but also about what those laws say, how they are created, and what values they promote. To put a counterexample, a very easy one, North Korea also has a legal system, I guess, and they abide by their national law. But the quality of those laws and how they are passed is what turns this country into a human rights violator. The law must have democratic legitimacy, meaning that it must be created through democratic processes, and it must serve to protect people's rights and freedoms. That's why when we talk about the rule of law backsliding in the European Union, we are not only describing a legal problem, we are talking about a deeper crisis. I would say it's a crisis of identity, because what it is at stake in the Union today is its credibility, and not only its credibility, but its survival. No one knows how the European Union will evolve in the future, but what is certain is that it can't evolve, it cannot possibly evolve into a community of non-rule abiding states, or as they are called now, a union of illiberal states or autocratic states. If the European Union abandons its values and founding principles, it will collapse. This is why the crisis of the rule of law can easily turn into a crisis of human rights, and a crisis of human rights can easily turn into an identity crisis. And however, what we see sometimes also in the European Union is that other interests have been placed ahead of these values, which has created tensions and undermined the European Union's legitimacy. In short, respect for the rule of law and protection of human rights is what allows any entity, including the European Union and also the USA, to speak with moral and political authority, both to its own citizens and beyond its borders. Second part, To understand what is at stake when the rule of law is eroded, in my work, I will examine the 4 key elements that the European Union identifies as fundamental to a genuine rule of law system. These are judicial independence, media pluralism and freedom of expression, the fight against corruption, and the existence of robust checks and balances. My goal here will be to show how these 4 elements are directly connected to the protection of human rights, and more specifically, how judicial independence supports the protection of all human rights, both individual and collective rights, how media pluralism and freedom of expression ensure visibility and respect for human rights, how fighting corruption promotes transparency, justice, and equality, all of which are, of course, essential rights, and how checks and balances prevent abuses of power and uphold institutional accountability for human rights violations. Because according to the European Commission's Rule of Law report, that now has already 5 editions, a robust and healthy rule of law regime is one in which judicial independence is respected, corruption is combated, freedom of expression and media freedom are upheld, and strong checks and balances are firmly in place. But in the area of the rule of law, we cannot forget that the Council of Europe paved the way for the European Union. And in 2016, the Venice Commission, the Commission on Democracy Through Law, outlined in its rule of law checklist that the rule of law requires a legal system where laws are clear, predictable, and consistently applied. Individuals are treated with dignity, equality, and rationality by decision makers. Decisions comply with established laws. Individuals have the right to challenge decisions before independent courts through fair procedures, and authorities and policymakers and decision makers are equally subject to the law. Needless to mention that all the key standards identified in the rule of law checklist by the Council of Europe directly touch upon specific human rights. At this point, to substantiate the links between the elements of the rule of law and human rights, in my perspective paper and contribution, I will also draw on the International Covenant on Civil and Political Rights, in addition, of course, to the European instruments. Why will I bring this UN instrument into the picture? Well, it's obvious. It is because I will conduct a comparative analysis of the situation in the European Union and in the United States, focusing on the increasing erosion of the rule of law in both continents and the weakening of human rights protections in both geographic contexts. And I cannot apply European tools to the USA. So I delve into the 3rd part of my expose today. If I'm not wrong, the purpose of my contribution today to this workshop is to explain how I am approaching my research topic, which I hope I did, what I have done so far, what still needs to be done. I hope I was clear enough about what still I have ahead. And the last point is what my main concerns or potential limitations are, so I can receive feedback from you as experts. If that's the case, I would like to share with you my current concerns and my open questions, which I hope to clarify through your insights and comments. So my first concern is, it's 5 concerns, I think. My first concern is about the correctness of the comparative framework. Since neither European Union law nor Council of Europe instruments apply to the United States, I've chosen, as I say, the International Covenant on Civil and Political Rights as the most appropriate common framework, because it provides a shared basis, since both the US and the European Union member states are parties to it. But that said, I'm aware of a potential limitation in this approach. I'm not entirely sure whether the 4 key elements used to define the rule of law in the European Union are understood in the same way in the US context. For example, what was striking to me during my time in the USA since the month of January is that I have noticed that in the American tradition, the rule of law is often associated with some specific areas that are somewhat foreign to European legal thinking on rule of law, such as, for example, national security or tax policy or national guards. this is something I need to explore further as the research evolves, because I'm probably too stuck on freedom of expression, judicial independence, fight against corruption, and check and balances. Second, I have this concern about the scope of the analysis, because I'm not sure if I will be able to meaningfully explore the connection between all 4 elements of the rule of law and the human rights violations associated to them in the space of a single article, of a journal article. I have already started working, but I fear that the topic may be too broad. So I'm really considering narrowing my scope, my focus, perhaps addressing only 1 or 2 of the 4 dimensions, for example, judicial independence and freedom of expression. My third concern is about the selection of case studies. I also doubt whether I will have the time and the space to include many European case studies, or whether I will have to choose maybe 1 or 2 of them. For sure, I plan to include the most paradigmatic, longest-standing case, which is Hungary. That's for sure. But I am also considering adding a second country, but not more than that. And I'm still undecided whether to add Spain, Romania, Slovakia, Croatia. But I do not think I will have the time, the energy, and the means to go further than 2 cases from Europe besides the US case. Fourth, I am also concerned about the time frame. The question I'm still reflecting on is whether I should limit the research chronologically, for example, by focusing only on the post-pandemic period. The pandemic may have altered some dynamics significantly. So defining a clear time frame could help focus the analysis and avoid distortions. And fifth, last but not least, another question that I will have to address is about sources and language. In this respect, I'm concerned about the availability and reliability of sources, because many of the documents I am finding are media reports and opinion pieces from newspapers, very prestigious ones, of course, and media outlets. But I do not know if this is okay. Maybe I have I'm very narrow-minded because of my legal background. Of course, I will rely as much as possible on official legal texts at the international, European, and national levels. But I am not sure if I will be able to locate and to translate all relevant documents, for example, concerning cases like Hungary. These are the concerns I have identified so far, and I would be grateful to receive your feedback, your suggestions, and reflections, because they will help me to refine the project and move forward with clarity. So this is what I wanted to share.
Thank you very much. Much appreciated. Thank you. Okay, so another Oxford person, delighted to invite Dr. Felix Martin Moreno, who is lecturer in marketing at Lancaster University here in the UK. His primary areas of research are corporate social performance, organizational anthropomorphism, the organizational virtues, marketing communications, and ethics in marketing and sustainability. Felix, over to you, please.
Thank you very much. Yeah, I went to Exeter College, where I read law many years ago. And then for various reasons, I ended up doing marketing, did a PhD in marketing, and now that's what I teach. So I feel a little bit out of place in some ways, really, with some of the backgrounds of the participants. I'm very grateful to Carlos to invite me along. I think I'll have to judge whether there is a perfect fit here. But I think there is, and the more I'm hearing what everybody is talking about, the more I can see connections, and I get more enthusiastic about my own topic. Now, the way I've approached this issue, or my interest really, lies in fundamental questions around what human rights are and how they work, and whether they really benefit the people that are entitled to benefit. So coming here from a social justice perspective, and I suppose ultimately, really, the question that's in my mind is somewhat. I've shared my screen. I don't know if you can see it, but I just thought I don't have a slide, but I may take you through my text. That for me, the key question is much as there is a whole question around natural law and the law. What is the underlying kind of values really that underscore the drafting of laws. I also have a question around the underlying values that underscore the drafting of human rights and how they're meant to be implemented. And my impression is that many times, although there are human rights that should be applied, and there's been a discussion about this in relation to Israel right now, that often they are interpreted in ways that don't really benefit the people they're supposed to support. And the enforcement of the rights are not structured to really meet their needs. And so one gets the impression, and there is literature around this, that human rights are drafted with a sort of developed country perspective in mind, a mindset, and that creates a whole difficulty in terms of how they should be understood and applied. And there's therefore a sort of a breakdown in the discourse between the needs of peoples and the application of the rights. So that's my kind of background to this. And therefore, if you just sort of take you down my brief abstract, it's precisely that. The universality of human rights is frequently challenged. Okay, and that many countries, like the US, are saying, well, now we don't like the human rights. We get out of the Human Rights Council, and so many countries are now opting to do that. Hungary is now considering that themselves, and at the same time, many developing countries, they argue that when companies come to do business there, they don't really they choose which human rights to enforce, and then they use all kinds of mechanisms to get around obligations that would be apparent to anyone from that country, but they're not apparent to these companies or the people from developed countries. And so that's the kind of problem there. And I think the accusation often is that the human rights really have been drafted to benefit Western governments, that they are having drafted with a market logic lens, and that they operate on economic rationality, which often clashes with community values. And so this underlying, this background to the drafting of human rights imposes unspoken conditions on human rights. And then, many of the words that have been used in human rights laws, they really come from developed markets that maybe don't make any sense in some of these developing economies, which are much more communitarian and collectivistic, like individualism, rights itself, what is a right, democracy, the common good, equality, statehood. So some of the challenges that terminology can pose, and some of these biases, interpreted in a way that benefits certain ways of thinking, can worsen inequalities. They can be used to justify repressive policies or access to human rights institutions. So I think that non-Western societies that are trying to build a nation, have economic growth, they may find that sometimes the human rights are used to pin them down, not to enable them to actually progress and develop. And what is civilized and how they should develop is really marked by these human rights interpretations, which often take a very Western view of how to do things. And so that's a little bit of the background to that. There's been an attempt recently by companies in developing countries, especially in Bangladesh, to create market protected spaces. It's a very interesting article in the Management Review where they say that, you know, following the Rana Plaza disaster, the whole world realized actually that companies in the West operating in Bangladesh and other locations like that, they are not really working to support the local people, and disasters happen, and these companies got a lot of money and they're not applying it in the right way, and therefore, what happened when this disaster occurred is that they all said, all the companies whose names were being soiled by this event of the collapse of the roof and killing lots of people, they all said, actually, we need to do something different. We need to really start enforcing these rights. And so they created these market protected spaces, so spaces of action in those developing countries that we protect from the market perspective. They would apply a sort of a ground up view to how the company should deal with people there and relate to those communities, and that was all very good. I mean, it was very impressive, you know, that companies make big commitments to improve their processes, to really reach out to those people and work in a very clean way. But obviously, the rationale was reputation saving. So those companies, once the pressure of reputation faded, then all these companies began to cut corners again and to try and started going back to the old habits, really. And so the notion of responsible management that reasoned from this experience again was diluted, because ultimately the logic with which they're operating is one of competition. is a Western logic. Is trying to, and so yes, they make a pause in that logic for a while and to save their reputation, but ultimately they go back into it. It's the natural process. So there's been no fundamental change in the way that human rights are interpreted or enforced. So there are questions emerging as to, you know, how could this change? You know, for example, we have the logic of adopting a more relational approach to how human rights are conceived and how they are enforced. You know, common interests, you know, let's talk about common interests, developing common interests and growing communities, turning market exchanges into exchanges based on social relations, a few other ideas out there, Polanyi and so on. And you know, increasingly culture is being more and more discussed as an element of human rights. And so you know, how human rights protect cultures and so on. But again, it's a very raw debate, I think, at the moment. We're still being seen through very complex eyes. And so I think that the question ultimately is, you know, how do we bring in the subjective dimension into something that is considered to be an objective thing? You're all talking about laws there. The laws say this, the laws say that, they're also enforced. I think the last speaker talked about, you know, questioning the law. What is the law? You know, and I think that's what I'm trying to do as well. And so, you know, how do we bring the subjective perspective of the people who are at the bottom of the pyramid? Okay, and I think that you know, human rights, I think expressions like promoting universal peace and justice, social progress, and standards of living can actually work against those people, because they're all ideas from the West, if you like, the ideas from a very utilitarian perspective on life. We're supposed to achieve social progress. Okay, what is that? And I think that you know, in any case that you pierce these things together, you're going to end up with a Hobbesian Leviathan. So some form of you know, stronger, the stronger controlling the weaker, really. So I think that perhaps all of this is saved really within the Convention of Human Rights if by one sentence, I think, which is the dignity and worth of the human person. And that's a one sentence which really allows the subjective to be incorporated and to be brought up and to be given priority. Especially if you adopt a sort of Hofstadtian lens for the interpretation of rights, one which demands a response. So I think that what I kind of am proposing is that the foundation of human rights law should be based on psychology. So the idea of developing the psychological growth of people. That should be the objective, and that includes satisfying psychological needs like food, safety, social support, mastery, respect, and autonomy, but also ensuring that when human rights are interpreted and they are enforced, that what is really the central focus is the fact that people have to experience personal development, personal growth, and I think that there are ways to measure this. There are tests, there are ways to test psychological growth and development, and it is perhaps something that could be considered. There's also the possibility, maybe which I'll tackle as a second part of my paper, to adopt Bourdieu's concepts of social capital and cultural capital, and work also at a more the meso level, not just the individual level. But in a sense, it's kind of calling into question what are we really trying to achieve with these human rights, because ultimately they can be instruments of coercion as much as instruments of development. So I think that basically is where I am at. It's not too far really, but that's my interest. And I think that in terms of the digital era, well, I haven't really given up much thought, I should say, but I think that, again, given that people now have access to digital means and so on, that could be used to help implement a kind of these psychological measurements and that kind of thing that I'm talking about. So anyway,
Felix, thank you so much for that.
Thank you.
You've really widened the debate enormously, opened up some very fundamental questions for us. And now we actually turn back to Carlos, to Professor Carlos Espaliú Verdud, who, of course, we are delighted to have as a research fellow here at Blackfriars in the University of Oxford, but who is also full professor of public international law and international relations at the University CEU Fernando III in Seville. He's been a legal officer at the International Court of Justice, director of the Charlemagne Institute for European Studies in Barcelona, Secretary General of Nebrija University, and director of its Research Center for Security, the Rule of Law, and High Technologies, that in Madrid. And of Carlos's main areas of research include the use of force in international law, disinformation, human rights, the peaceful settlement of disputes, European citizenship, and the law of the sea. Carlos, over to you. We've heard so much this evening already. How would you like us to take it forward in this final part of the webinar this evening?
Thank you very much, Richard, and Melit, for letting me organize this event. I hope it is fruitful for the audience and for the research work of the Institute. I will try to be brief because I would like to put an end to this workshop around 7:30 here in Spain, so 6:30 in UK. So we have 15 minutes. But as much as my work is also in progress, I will limit myself to share with you only my introduction. So I am going to talk about St. George and the New Dragon, the fight of the European Union against disinformation sponsored by foreign states. So I am very much concerned about this topic because, as you probably are aware, disinformation campaigns sponsored by foreign states, mainly by Russia and China, mainly by Russia, they are affecting the human rights of European citizens. I think I chose that topic to deal with in this workshop, in this project of highlighting the crisis of human rights in Europe and the problems ahead that European Union and Europe in general has in front of it. No? So you know that the use of false information is inherent in the human condition and has traditionally being used to manipulate public opinion for military, economic, or political reasons. But nowadays, due to the technological revolution, the scope and danger of this threat is enormous, mainly when it takes the form of disinformation campaigns. For us, for me, this new form of information disease, the disinformation campaigns, are can be defined as orchestrated dissemination of untrue news or data through traditional means, media outlet like printed press, radio, or television, or through new channels like a social network, with the aim of taking advantage taking economical, political, or strategical advantage of harming rivals, be they individuals, entities, or even states. In this article, I will focus on the international relation and geopolitical landscape, mainly focusing on the fight of the European Union fight against disinformation when those disinformation campaigns are sponsored by foreign states. This threat cannot be underestimated when you realize that those campaigns can affect seriously fundamental rights, which are at the basis of our democratic societies, mainly in Europe. For example, those campaigns can be directed to when they are directed to individual candidates, it can affect the right or the fundamental right for freedom, for free and fair elections. And when those campaigns, disinformation campaigns, are addressed to the honor of the reputation of some public figures like journalists, academics, or judges, it can affect the right of own reputation or own honor. Finally, when those disinformation campaigns are directed against certain groups like women, ethnic groups, or migrants, for example, and inciting violence or hatred, it can affect those disinformation campaigns can affect the right to non-discrimination. But not only the disinformation campaigns are a danger for the rights of the citizen, but also for fundamental values of the states and the international organizations themselves. For example, disinformation campaigns orchestrated by foreign states can be considered an interference of foreign interference of states, and therefore amount to more or less violation of the use of force in international law embodied in Article 2.4 of the United Nations Charter. For example, in NATO, some documents in the strategic document of 2022, the NATO has said that the disinformation campaigns, together with other elements like cyber attacks and some military elements, can amount to hybrid warfare, and therefore they open the door to reaction invoking the Article 5 of NATO. It also has been said also in other strategic documents by national state like Germany some years ago. So we see that this threat of the disinformation campaign can affect fundamental rights of citizens, but also fundamental values of the international organization and state themselves. That's why I have chosen to study this fight by the European Union against this disinformation campaign sponsored by foreign states. I think this study can lead us to evaluate the effectiveness of those measures that the European Union is implementing so far, but also can lead us to get into some interesting topics of international law, of some novelty, like, for example, the self-defense of international organization in international law. I think the opportunity to conduct this study of the research is high, in my opinion, because you see, for example, the High Representative for Foreign Affairs and Security Policy of the European Union just some months ago in March, in her foreword to the third EEAS report on foreign information manipulation and interfering threats, has said that the information space has become a geopolitical battleground, and that the FIMI attacks, the foreign information manipulation and interference attacks sponsored by foreign states, is becoming a major threat for the European Union. Therefore, in addition to the introduction, and my article will have 3 other sections. The second will be devoted to examining the policies and measures adopted by the European Union at the beginning of the disinformation threat crisis, which can be characterized as a weak response. I have called this period the paper war. In the third section, we will look at the period in which the European Union is already taking strong measures to counter FIMI operations. I have called this period the real war, and finally, we will draw our conclusion. Thank you very much. I think we can have some time of debate, but I thank you very much, Richard, for letting me organize that and for moderating this workshop today.
Thank you so much, Carlos. We have time just for 1 or 2 very, very brief comments, I think, rather than questions. If people would like to use the raised hand toggle on the Zoom, do please, if you have a quick comment you'd like to make. We've heard so much by way of rich input, and so many themes have been opened up.
If you allow me, Richard, I would like to
Yes.
ask Sonia that what does she think about this news that came just yesterday, when the UK, France, and Canada are saying that they are considering taking reaction against Israel conducting in Gaza now. So do you think this is part of the putting into practice the obligation of the European Union, not only the European Union, but also the UK and Canada now? Is something like that?
Could I add, excuse me, on that as well? Because I found Sonia's words are really interesting, but I was wondering whether you think also that maybe your work may change, or the results may change in view of the new advisory opinion that has just been presented in the International Court of Justice concerning the closure of the UNRWA agency, of the first agency ever of the European Union. I was wondering whether you think that this may have any effect on your work.
Okay, so I'll start with the legal question. It's gonna have an impact, because eventually, I mean, I'm not gonna be focusing on the advisory opinion, but also on the duty to prevent genocide, because it's a legal duty under the Genocide Convention. That's one of the unique things about the Genocide Convention, that it has a clear duty that states should kind of prevent genocide, not by their own, agents, but it's a general duty that we all, the international community. So I'm gonna see how this is going to be linked to, this duty, how Israel's, decision to kind of close down and attack the only agency that has been able to kind of, do something which is minimal. I don't know if you followed the news, but from the UN saying that if you don't allow food, there are 14,000 kids at the risk of dying in 48 hours. I think, Carlos, that the Israel complete outrageous disregard of not basic international law norms, but basic principles of humanity and morality is making it impossible for countries to keep pretending this is not happening. So it is too late. It's a genocide that could have been prevented. And I'm going to use the word genocide because I fully support the analysis of the UN rapporteur Francesca Albanese in her various two reports on that. I fully support the analysis of leading genocide scholars such as Omer Bartov, Ras Segal, Derek Moses, Lee Mordechai. But I think, even if it's too late, it's better than, continuing with this. I don't know. I mean, it seems to be more than a threat than actually like wanting to do something that is decisive. Let's see if it works. I don't know. But it seems Israel it's not going to retract anytime soon.
Thank you very much, Sonia.
I have a comment to Susana, actually. When you were talking, I was thinking, did you read Jeremy Waldron's work on the rule of law? Now, Jeremy Waldron is, he's from New Zealand, but he's like, teaching at NYU. I think one of the leading, scholars on the philosophy of law. And what is interesting when he writes about the rule of law, he writes about the rule of law, what he calls like procedural rule of law, which connects to the things that you want to. Like independence of judiciary and having a functioning legal system. So I think it would be a good idea for you to read Waldron's work, especially the way he talks about what he called procedural rule of law, that connects more to the things that is maybe this could facilitate some sort of comparison in a way that is more kind of flowing. Thank you.
I thank you for that. Yeah, well, I have been given the names and the contacts of so many people, but not precisely of this person. So I will check on him. And yeah, thank you very much. As I say, my main problem is whether the same categories apply in both. They should apply anyway. That's my personal thought. Is like human rights should be the same everywhere. Rule of law should be the same everywhere as well. That's what I think. But it is true that I prefer to check whether the elements and the variables are exactly the same that we use in both continents. So thanks for that. I will check on this guy. Thank you.
I am very sorry to say that we have run out of time. We have had so much rich material, so many important points have been raised in the course of the last hour and a half. I'm sorry, I must apologize to those people who haven't been able to contribute directly. If you wish to contribute, comment, or ask questions, if you email them to lascasas@bfras.ox.ac.uk, we'll be able to pass them on to the participants via Carlos. So there is at least that opportunity. But I would like to thank very much indeed all our participants this afternoon, all our speakers, who have really led us into such important areas, both of law and life. And I thank you very much. And Carlos, we very much look forward to the next webinar in this series as you take these themes forward. Thank you for your work in doing this.